Hello everyone, I'm Maratra Kabhomik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to high courts and other subordinate courts. If you like our content, then it would mean a lot to us if you could please like and subscribe to our YouTube channel. Let's begin. The Supreme Court of India today declined urgent hearing of the PIL filed by religious leaders Swami Avimukteswaran and Saraswati pertaining to the recent land sinking incidents in Joshimath and instead posted the matter for hearing on January 16th. The counsel appearing on behalf of the petitioner today asked for the matter to be listed tomorrow, stating that it is quite urgent. To this, CJI D.Y. Chandrachud, however, stated, and I quote from his oral remarks, "Everything which is important in the country need not come to us. There are democratically elected institutions to see this. They can deal with what falls under their control. We'll keep it on 16th. We have made a detailed video on this development, the link to which has been given in the description box below. Please do check it out. As per a notice issued yesterday, the Constitution Bench led by Chief Justice of India D.Y. Chandrachud today assembled after CJI Chandrachud and Justice P.S. Narasimha's division bench heard mentioning matters. This is contrary to the usual practice as per which the CJI sits in a Constitution bench and mentionings are made before the next senior judge. On days when the CJI is not sitting in a Constitution bench, matters for urgent listing are mentioned before the CJI, following which regular matters listed for hearing are taken up. Don't tell me practice, I'll decide what practice happens in my court, CJI D.Y. Chandrachud orally remarked verbatim today, irked by the submissions of senior advocate Vikas Singh seeking listing of a case. Singh had mentioned a case regarding allotment of chambers for lawyers. However, the CJI told him that listing this week may be a little difficult. The CJI expressed his willingness to take up the case on 3rd February. However, Singh insisted that the matter be heard at the earliest. This prompted CJI Chandrachud to pass this remark. A Constitution bench of the Supreme Court of India has listed the petitions concerning the constitutional issues arising out of the rift within the Shiv Sena party between Eknath Shinde and Uddhav Thackeray on 14th February this year. The matter was listed before a bench comprising Chief Justice of India D.Y. Chandrachud, Justices M.R. Shah, Krishna Murari, Hema Kohli and P.S. Narasimha. Apologies for the delay in delivering the judgment, said Supreme Court Judge Justice B.R. Gavai today, setting an example to be followed by the judiciary. A Supreme Court bench of Justices B.R. Gavai and M.M. Sundaresh was pronouncing the judgment in a petition against the rampant practice of the conversion of single residential units into apartments in the city of Chandigarh. We had to consider all provisions of the various acts and the rules promulgated under them, the judge said, explaining as to why the judgment pronouncement was made in a delayed fashion more than 2 months after it was reserved on November 3rd last year. Today, the Supreme Court of India took serious exception to young lawyers coming to court without sufficiently preparing for cases. We are noticing the younger members of the bar, they will do everything else except coming prepared. Don't come to the court if you're not prepared with the matter. You're supposed to be fully prepared whether your senior is prepared or not, a bench of Justices Dinesh Maheshwari and Rishikesh Roy advised today. This particular bench was prompted to make these observations after it noted that an advocate had come underprepared for a case. He had sought for a passover in this matter. In a significant development, the Supreme Court of India today slammed the rampant practice prevalent in Chandigarh city of converting single residential units into apartments in view of the heritage status of India's first planned city as well as the principle of sustainability, noting that the Union Territory Administration had repealed the controversial Chandigarh Apartment Rules of 2001 that sought to regularize this practice, a division bench comprising Justices B.R. Gawai and M.M. Sundaresh held, and I quote here, in light of the relevant acts and rules and the repeal of the 2001 rules, any fragmentation, division, bifurcation of a residential unit in Phase 1 of Chandigarh is prohibited. The Bombay High Court today refused to restrain the National Testing Agency from conducting the JEE Mains 2023 examination on the scheduled dates. The bench of Acting Chief Justice S.V. Gangar-Purwala and Justice Sandeep Marne ruled, and I quote, any orders passed to postpone may have a cascading effect. If a student does not fare well in JEE January, he can compete in April. Extraordinary circumstances don't seem to exist. It wouldn't be appropriate to restrain the respondent from conducting a pan-India exam. Justice Rajashekhar Mantha of the Calcutta High Court today initiated suo motu criminal contempt proceedings against lawyers who had held protests outside his courtroom on Monday. On Monday, large-scale chaos prevailed outside the courtroom of Justice Rajashekhar Mantha after a section of lawyers prevented him from continuing with proceedings. Several posters describing Justice Mantha as a disgrace in the name of the judiciary were seen pasted inside the premises of the Calcutta High Court as well as near the judge's residence in South Calcutta. Due to this ruckus, proceedings of Justice Mantha's courtroom had to be temporarily stalled. It may be noted that Justice Mantha on December 8th last year had passed an order staying over 26 FIRs lodged against BJP MLA and Leader of Opposition in the Assembly Suvenendu Adhikari and had directed the state government to take the permission of the court before lodging any further FIR against him. Earlier, Justice Mantha had also removed protection granted to Menaka Gambhir, the sister-in-law of TMC General Secretary Abhishek Banerjee, in a money laundering case. While arguing an appeal before the division bench of the Telangana High Court against an order of the single judge handing over the probe in the BRS MLA's poaching case to the CBI, Senior Advocate Dushyant Dave today said, and I quote, all constitutional institutions are gone. Judiciary is loved the most these days. Mr. Dave was arguing on behalf of the state of Telangana in the matter where he was trying to press the point that it is only the constitutional courts that common citizens of this country could turn to given the present circumstances of the country. Expressing a prima facie view, the Delhi High Court has observed that the complaint of a sexual harassment and inquiry proceeding cannot be quashed merely because the Internal Complaints Committee, that is the ICCC, failed to complete inquiry within the time frame of 90 days mentioned under Section 11, subsection 4 of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. Justice Vikas Mahajan ruled, and I quote, needless to say that such complaints containing allegations of sexual harassment deserves to be treated with a certain amount of seriousness and responsibility, and accordingly the same have to be inquired into and taken to the logical conclusion for it, both in the interest of the complainant as well as the person against whom the allegations of sexual harassment have been levelled. Thank you. Keep watching Courts Today on LiveLaw for more such updates. See you tomorrow.